All right, so I'm going to go ahead and let people in. All right, hello everybody. Welcome to the Colorado HOA Center's HOA Forum on Association Records and Disclosures. It's 1 o'clock, and we're going to go ahead and start this forum. Just real quick, I'm going to let Brian Tobias make a quick announcement on the HOA Center's sunset review. Hi, Brian. Go ahead and take it over.
Hi, thanks so much, and thanks for allowing me to come in. Um, my name is Brian Tobias. I am the director of the Colorado Office of Policy Research and Regulatory Reform, and I just wanted to take a few minutes today to let everyone on the call know that my office is starting to conduct a sunset review of the HOA Information and Resource Center. It's a fairly common practice in Colorado state government. This is the second time I know the center has gone through a sunset review. And basically, my office conducts all of the sunset reviews in Colorado state government. And as part of that review, we're really looking to see whether the HOA Information Center should continue, and if it should continue, whether we need to make any changes to it. Part of the way we make those decisions or make those determinations is to engage in stakeholder outreach. And so I wanted to take the opportunity today to let this wide audience know that we are conducting the sunset review and to afford you all the opportunity to participate in that sunset review. So when I'm done talking here, I will put into the chat a link to my office's website that allows people to comment on any of our sunset reviews, but particularly this one. And if for some reason that doesn't work, there is a link to my office's webpage on the HOA Information Center's webpage as well. So if for some reason I mess up putting it in the chat, which is entirely possible, you can find it that way as well. Couple things about the sunset review. Our research phase is starting now, so that will run through late spring, early summer, and then the report will come out in October. Our statute requires us to publish those reports on October 15th, and that report will recommend to either continue or sunset the center. And if we recommend continuation, we can then make additional recommendations to the General Assembly as to how we think they ought to change the statute around the center. One important thing I know it's important in this particular context is that this is a sunset review of just the HOA Information and Resource Center. It is not a review of community association managers. It is not a review of Kiowa. It is not a review of HOAs. It is really just about the information center itself. And with that, I think I'm done. I don't want to take up too much time because I know you guys have a lot to cover today. Really just wanted to take the opportunity to introduce myself, give you the information so that if you do want to participate in the review, you've got it. So thank you very much. I will put that information in the chat as soon as I turn my camera off, and I appreciate the time. Thanks.
All right, thanks, Brian. All right, so again, this is our HOA Forum on Association Records and Disclosures. I also have Amanda Lopez here with me today. If you want to unmute and just say hi, Amanda, how you doing? Hey, Amanda.
Hi, everybody. Thank you for joining the forum today, and happy Friday to all.
Appreciate it. Amanda's going to help me monitor the Q&A section So today's Friday, January 26, 2024. Just a couple housekeeping items before I begin. For this forum, the Q&A feature of Zoom will be enabled. At any time during the presentation, if you have a question, simply click on the Q&A button on the bottom of your Zoom interface panel. And if you wouldn't mind, please ensure your question is related to association records and disclosures to the best of your ability, just so we can properly answer those. All right, and just as always, a quick disclaimer: the information presented in this presentation is intended for educational purposes only and should not be construed as legal advice. Any legal questions should be directed toward a qualified licensed attorney in Colorado. I usually like to start our forums off just with what the HOA Center does and does not do. So the HOA Center, we provide information to homeowners regarding their basic rights and responsibilities under HOA. We gather, analyze, and report information through complaints and HOA registrations. We create resource materials and education and forums. We have a website. We register HOAs. And we also provide an annual report to the state legislature. What we do not do is mediate or arbitrate on behalf of homeowners, board members, or community association managers. We do not act as a regulatory program. We cannot provide legal advice. We do not investigate or intervene in disputes that arise between homeowners or their associations. We cannot act as an advocate. We do not have the ability to assess fines or penalties. And finally, we do not enforce an HOA's failure to register. All right, so again, this is on association records and disclosures, and I have a couple polls here. I just want to gauge the audience's knowledge here. I'm going to drag this. So you should see a question on your screen. As a unit owner, I know how to submit a proper records request to my board community manager. Yes or no to that question? And as always, we have a wide variety of consumers join us, both unit owners and community managers, board members. So it's always interesting to understand the results of these polls. Let me see if I can share this. So we had about 77 folks say yes and 32 say no. Get one more. All right. Second question here is, as a unit owner, my board community manager makes it easy to request records and provides them in a timely fashion. We had about 78% say yes and 22% say no. As a board member or community manager, I can confidently supply the required records to a unit owner on their request. And there's no right or wrong answer. Had about 64 say yes and 11 no on that one. All right, one more here. As a board member, community manager, how often do you receive a request for records from a unit owner? Never, a couple times per year, once or twice per week, or more than twice per week? All right, so we had 22 say never, 68 a couple times per year, majority just a couple times per year. And yeah, there are the results for you. All right, let's get into the slides here. So, all right, so there are 19 items that Kiowa defines associations must produce to owners, 19 items that I've identified here. So I'll start and I'll go through each one here. If you can see my laser pointer. So number one, and this is according to Kiowa 38-33.3-317. The first item is any records that are required to be produced according to the association's own declaration and bylaws. So what that means is the association might already have its own list of records that it deems necessary to produce or maintain on unit owner request. Number two is annual disclosures as required by Kiowa section 209.4. Number three is receipts and expenditures affecting association operations. Number four is claims for any construction defects. Number five is minutes of all unit owner or board meetings and actions taken without a meeting. Number six is written communications and votes cast by board members outside of any official meeting. Number seven is name and address of unit owners, and we'll get into more information on this one. Number eight is the association's current governing documents. Number nine is 3 years of financial statements and 7 years of tax returns. Number 10 is certain contact information for the board members and officers. Number 11 is a list of all fees connected to the purchase or sale of a unit, i.e. transfer fees and status letters. Number 12 is the association's most recent Secretary of State annual report. Number 13, a written statement requested by a unit owner setting forth the amount of unpaid assessments currently levied against said unit owner's unit. Number 14, the most recent reserve study, if any exists. Number 15, current written contracts and any contracts for work performed in the preceding 2 years of the request. Number 16, any board or committee action to approve or deny a unit owner's request for an architectural design modification to said unit owner's unit. Number 17, ballots, proxies, and other voting records related to voting by unit owners for 1 year after the election, vote, or action to which they relate. Number 18, any resolutions adopted by the board that affect unit owners' rights. Number 19, and last one, all written communications within the past 3 years to all unit owners, generally as unit owners. Some of these may sound a little confusing, but I will clarify as we advance here. All right, so first one is records required. So as I said previously, associations may have their own list of records to be maintained and produced on unit owner request, which is typically fine as long as the retention and production of such records is not in violation of the provisions already set forth in Kiowa section 317. For example, what I mean by that is if the association has, say, a list of social security numbers or telephone numbers and email addresses that an owner did not consent to providing the association, and if that association was producing or publishing that list, the association may be in violation of state law. Number two, annual disclosures 209.4. These are records that the association already must be disclosing within 90 days of the end of the current fiscal year. However, this also means that if a unit owner requests any of these records, they must be produced as well. So these records include the name of the association, the name of the association's designated agent or management company, if any, a valid physical address and telephone number for both the association and the designated agent or management company, if any, the name of the common interest community, the reception number or book and page for the main document that constitutes the declaration. That would typically be found at the county clerk and recorder's office. That's what reception number or book and page mean. The date on which the association's fiscal year commences, the association's operating budget for the current fiscal year, a list by unit type of the association's current assessments, including both regular and special assessments, the association's annual financial statements, including any amounts held in reserve for the fiscal year immediately preceding the current annual disclosure, the results of the association's most recent and available financial audit or review, a list of all association insurance policies, all the association's bylaws, articles, and rules and regulations, the minutes of the executive board and member meetings for the fiscal year immediately preceding the current annual disclosure, and finally, the association's responsible governance policies adopted under section 209.5 of Kiowa. Moving on to number 3 here, receipts and expenditures are basically any business transaction that results in a receipt or expenditure to the association. Those must be produced. These include payments to vendors, managing agents, attorneys, and any employees of the association. Number 4, claims for construction defects. More precisely, Kiowa states records of claims for construction defects and amounts received pursuant to settlement of those claims. Basically, if your association and possibly a unit owner is in a debate on whether a construction defect action exists somewhere on the property, an action, basically what a construction defect action is anything which could result in a claim, meaning any civil action or arbitration proceeding for damages brought against a construction professional to assert a claim for damages of real or personal property or personal injury caused by a defect in the design or construction of an improvement to real property. For more information on that, if you were curious or wanted to know, please see Kiowa section 303.5. But again, those records must be produced if they exist. Number 5, minutes of all unit owner board meetings. These minutes should be the official record of the meeting, or i.e. what actually occurred at the meeting. Usually that would mean approved meeting minutes of the board or the annual meeting. If the unit owner or board, and when it says actions taken without a meeting, that means if a meeting was held properly pursuant to the Colorado Revised Nonprofit Corporation Act section that describes members' action without a meeting, which is 127, 107, and 109, as well as 202 of the Nonprofit Corporation Act. Those sections highlight how a board may take an action without a meeting. So if the board takes an action, or if it does do that, then those records of any and all actions taken at said meetings must be produced. A record of all actions taken by any committee as well of the executive board must also be produced pursuant to this section. Note that Kiowa does not prevent an association from producing a draft copy of the meeting minutes, but any board that might elect to produce draft minutes should make it clear that the minutes are subject to change and are not an official record of the association. You might consider a draft watermark or the word draft in a conspicuous place on each page of the minutes to ensure clarity. Number 6, written communications and votes cast by board members outside of any official meeting. So more precisely, Kiowa states that 317(1)D, written communications among and votes cast by board members that are directly related to an action taken by the board without a meeting pursuant to the Nonprofit Act, or 2, directly related to an action taken by the board without a meeting pursuant to the association's own bylaws. Any action taken by the board without a meeting, either pursuant to the association's bylaws or state law, must be documented, maintained, and produced. That would include any communications in writing that directly relate to the action that was taken, such as emails, text messages, and social media IMs. Number 7, name and address of unit owners. This is 317(1)E. Specifically, this is saying the names of unit owners in a form that permits preparation of a list of the names of all unit owners and the physical mailing address at which the association communicates with them, showing the number of votes each unit owner is entitled to vote, except it doesn't apply to a unit in a timeshare. So note here that it does not include email addresses or telephone numbers of the unit owners. It only includes a list of the names and the physical mailing address at which the association communicates with them. However, if the association gets the owner's consent in writing that the owner is okay with sharing their email address and telephone number, then that should be acceptable. However, state law is only permitting a list of the names and physical mailing addresses of the unit owners. Number 8, current governing documents. This one's pretty straightforward, but it should include the most recently amended declaration, bylaws, articles of incorporation, or other org documents if it's not organized as a nonprofit corporation, such as an LLC. Rules and regs, governance policies per 209.5, and any other policies adopted by the board. These should all be made available and produced on request. This is actually an excellent item to include as a laminated 3-ring binder that you might, if you're a board member, you might consider bringing the binder to your board or member meetings for inspection and to allow your owners to examine these records. Number 9, 3 years of financial statements and 7 years of tax returns. So what exactly is how does Kiowa define a financial statement? Well, actually, 317 defines a financial statement. It tells you to go look at 7-136-106, which states the association's most recent annual financial statements, if any, and its most recently published financial statements, if any, showing in reasonable detail its assets and liabilities and results of its operations. Reasonable detail doesn't necessarily mean a comprehensive statement of cash flows and EBITDA, but it would be enough to give a scrutinizing eye probably a good sense of the assets, liabilities, and financial performance of the association. Tax returns of the association for the past 7 years, and note keyword here, it says in Kiowa to the extent available. Number 10, certain contact information for board members and officers. So here, Kiowa is more precisely stating at section 1H, a list of the names, electronic mail addresses, and physical mailing addresses of its current executive board members and officers. So officers generally include, some folks might not know, but that's usually the president, vice president, secretary, etc. Those are roles that once the directors are elected, they choose amongst themselves who should be the vice president, who should be the treasurer. Now this list does not include telephone numbers. It only includes the names, email addresses, and physical mailing addresses of the board members. Some HOAs opt to include one generic email address as its electronic mail address, while others might designate their CAM or community manager as their primary point of contact. Kiowa does not expressly prevent this or forbid this. Check your management contracts. Number 11 is a list of all fees connected to the purchase or sale of a unit. These are your transfer fees and status letters. Kiowa defines this to mean all unique and extraordinary fees that are chargeable by the association in connection with the purchase or sale of a unit and are not typically otherwise paid for through assessments, which would include transfer fees, record change fees, and the charge for a status letter or statement of assessments due. This one's pretty straightforward. Your most recent Secretary of State's annual report, which should also be available on the Colorado Secretary of State's website. So number 13 here, this one is a little tricky, but it's not that bad. It says a written statement requested by a unit owner setting forth any amount of unpaid assessments currently levied against that unit owner. So if you look in Kiowa, you have to do a little bit of digging, but it kind of leads you to other sections of Kiowa in the Nonprofit Act. But this one is saying financial records sufficiently detailed to enable the association to comply with section 3168 concerning statements of unpaid assessments. So according to this section, the association has 14 calendar days to furnish the statement to the unit owner. If the association fails to furnish the statement within 14 calendar days, the association has no right to assert a lien upon the unit for unpaid assessments, which were due on the date of the request. For more information, please see 3171J and Kiowa 3168. Number 14 is the association's most recent reserve study, if the association has any. So note here, if any. So that doesn't mean that all associations must have a reserve study. It just means if any exists, they must be produced. So note that there is no current law as of January 25th, 2024, or that was yesterday and today, that associations must conduct a reserve study. However, associations have to have the two reserve study policies in place. One is on the investment of reserve funds, and one is on when the association has a reserve study prepared. For more information, please see section 209.5, required governance policies. Number 15, current written contracts and any contracts for work performed in the preceding 2 years. Current written contracts includes the management company contract that's currently in effect, the association's contract with legal counsel, any contracts with vendors and service professionals such as snow plowing, landscaping services, maintenance, accounting, trash, utilities, etc. And also contracts for any work performed in the preceding 2 years must also be maintained and produced. Number 16, any board or committee action to approve or deny an architectural review request includes any vote that was taken by the board or committee to approve or deny a request for an architectural modification on a unit. Generally, this should be what should be adequate is how many fors and against were against such votes. For example, 5 fors and 3 against, or maybe 1 or 2 abstains. Number 17, ballots, proxies, and other voting records. This one's also straightforward. So election vote, any ballots or proxies that related to election votes have to be produced for 1 year after the election vote or action to which they relate. So if your association is holding an election February 15, 2024, the records of that election should be kept for 1 year. So all the way until February 15th of 2025. You might ask, like, what's the best way to dispose of records or record destruction? Your association should probably have a policy in place that speaks to that. It might be a good idea to speak to your legal counsel if you don't already have a policy in place on your record disposition policy. Next one's any resolutions adopted by the board that affect unit owner rights. This is a wide variety of resolutions, but they can include short-term rentals, resolutions on short-term rentals, safety in the neighborhood, or perhaps cyclist and pedestrian resolutions. And lastly here, all written communications within the past 3 years to all unit owners generally as unit owners. What does that last part mean exactly? It just means any communication that went out to all of the unit owners at once. So that could include like a newsletter, email notifications to the entire membership, or flyers, for example. Keyword written communications within the past 3 years to all the unit owners. Okay, so that summarizes what records must be produced. Let me just take a real quick look here at the Q&As, see if I'm able to answer any of these. Not seeing a poll. Let's see, Amanda, did you notice anything in there that?
Yeah, I've actually been going in and answering a few. I know we are getting a lot of questions on when the slides will be available. So I'm just kind of putting that in there. I am going through other questions, and actually, you guys have a lot of really good questions on here. So, one question we had, I know it doesn't have the name on here, but when you state what the includes when it comes to what the records have, is it they want to know when you say includes, does that mean includes but not limited to, as far as in the
Like a certain
association?
slide that they were referencing?
I'm not sure, but I'm not sure who asked that question, but if you want to go ahead and type in the same type of question, but just more information as far as what slide that was on. Another question we have
Includes.
is, what are the acceptable ways to provide the annual disclosure? Is there a website containing the information that is accessible to owners who qualify as the annual disclosure?
Kiowa outlines that exact process. I believe it's in 209.4. But off the top of my head, one of the suggested ways is just to maintain a 3-ring binder at the principal place of business. The association can also post on the association's website the required disclosures. There might be 1 or 2 other ways I'm not thinking of right now, but feel free to send us an email with that question.
Thanks. Another good one is, what if a unit owner does not want their mailing address given out at all, as far as what information they can?
State law mandates that an association must maintain a list of the unit owner names and physical mailing addresses. You might be able to work with your association to see if they'd be willing to keep your name off the list, but state law is currently requiring associations to maintain that list.
Okay, and Chris has a question. Chris Frazier, can a board member choose the property management address as a physical mailing address of the board member for the HOA matters? Correct me if I'm wrong, Nick, but as far as the HOA's address goes, I don't know if Chris is referring to like mailing addresses as far as individual mailing addresses or HOA registration address, but as far as that, it would have to be where the HOA is registered that you can use the address to. Is that correct?
Let me see. You might have to repeat that question again. Was that for? We'll do one more question here, but can you repeat that one for me, Amanda?
Yeah. Can a board member choose the property management address as a physical mailing address of the board member for HOA matters?
I believe so. I believe the answer to that question is yes, as long as it's a physical mailing address that the unit owners can communicate with, or that the association receives its mail, that it can receive its legal mail, then that should be adequate.
Thank you.
All right, let me go ahead and continue with the presentation here. We'll get to some more in a little bit here. So these records on this slide are records that may be withheld at the discretion of the executive board. Kiowa 3833.3-317 subsection 3. So beginning with architectural drawings, plans and designs, unless released upon the written consent of the legal owner of the drawings, plans, or designs. Contracts, leases, bids, or records related to transactions to purchase or provide goods or services that are currently in or under negotiation. So if there's no official contract or if there's no signed contract yet, the board can choose to withhold these types of records. C, communications with legal counsel that are otherwise protected by the attorney-client privilege or the attorney work product doctrine. D, any record that would be the disclosure of which would be a violation of law. E, records of an executive session of an executive board. F, individual units other than those of the requesting owner. Or G, the names and physical mailing addresses of a unit owner if the unit's a timeshare unit as defined in section 110.7. So F, some of these are a little tricky, but I'll try my best to kind of clarify. What is an individual unit other than those of the requesting owner? So maybe you might have a unit owner who wants to know delinquency information on his unit or on a couple of units in the community. The board, could choose to divulge that information, but best practice would be to redact personally identifiable information of the other delinquent owners or units. For example, out of 60 units, 5 are delinquent, or something to that extent. Any information that would be disclosure a violation of law. Again, usually that's personally identifiable information like social security numbers or email addresses if the owners did not consent to the sharing of their email address. Records of an executive session. The board, if they wanted to be transparent, they could disclose those records, but generally speaking, those records should be should not be disclosed. It's at the discretion of the board. And yeah, I think that about summarizes it. These are the records that the board has discretion on producing. All right, next slide here. So then lastly, which records must be withheld from production? These must be withheld from production. Personnel, salary, or medical records relating to specific individuals, or any personal identification and account information of members, including bank account information, telephone numbers, electronic mail addresses, driver's license numbers, and social security numbers. So those must be withheld from production. Right. So I thought it'd be helpful here just to have a summary slide of record retention requirements according to Kiowa and the Nonprofit Act. So how long must the association keep records on hand? Board and owner meeting minutes permanently. There's no, Kiowa does not set an upper limit for board and owner meeting minutes. They have to be retained permanently. Records of all actions taken by the owners or board without a meeting, for example, actions by mail or electronic mail, permanently. Financial statements as described in the Nonprofit Act, subsection 106, for the past 3 years. I talked about those a couple of slides ago, and tax returns of the association for 7 years to the extent available. Current written contracts to which the association is a party, and contracts for work performed for the association within the immediately preceding 2 years. Ballots, proxies, and other records related to voting by unit owners for 1 year, again, after that election, action, or vote took place. All written communications within the past 3 years to all unit owners generally as unit owners. I thought hopefully that would be a helpful slide to refer to for the duration of how long the most common association records must be retained. All right, so a couple important notes here. Associations are permitted to require requests be made in writing and be submitted at least 10 days prior to the inspection or copying of records. An owner is allowed to designate an authorized agent to examine or copy those records. Copy those records which must be produced by the association. And also associations may limit the inspection and copying of records to normal business hours or the next regularly scheduled meeting of the board if that meeting occurs within 30 days after the request. So they may limit it to normal business hours or the next board meeting, as long as that board meeting is scheduled within 30 days after the record request. Associations are allowed to impose a reasonable charge, which may be collected in advance. Again, we have that word that we all love, reasonable. Kiowa doesn't define reasonable, and ultimately a judge would have to be the one to determine that. If you as a unit owner believe that your association or manager is imposing too high of a fee, you would have to assert your own rights. Kiowa requires that owners assert their rights, either through alternative dispute resolution or litigation. Alternative dispute resolution, mediation, or arbitration, for example. The charge may not exceed the estimated cost of production and reproduction of the records. Owners may request and receive records by email. And again, any PII information or PII should be redacted to protect the confidentiality of unit owners. So sometimes the HOA center, we get questions about, well, what about membership lists? How are HOAs allowed to use those? So any membership list may not be obtained or used by any person for any purpose unrelated to a unit owner's interest as a unit owner without the consent of the board of directors. Again, keyword, board of directors, it's up to them whether they want to, what they want to use, how they want to use that membership list. The list may not be used to solicit money or property unless such money or property is used solely to solicit the votes of the unit owners in an election to be held by the association. The list may not be used for any commercial purpose, and the list may not be sold to or purchased by any person. This is also in Section 317 of Kiowa. I thought it'd be helpful to include a request form that unit owners, if you're a unit owner and you're kind of wondering, well, how do I go about requesting records? Can I text them? Can I email the board? Can I just telephone them? Generally, the request should be in writing, first of all, and it should be enough information to that where the association can properly identify which records you're requesting, and as well, your name, basic information like who you are, what unit you live in, so on and so forth. But there is a link here that contains a form that is suggested you use as the unit owner to make the request as simple as simple and easy as possible for your manager or HOA to work on. So just a couple tips for the boards and CAMs. Feel free to send out the disclosures, for example, with board or meeting notices to save on mailing costs, or post on the association's website. Feel free or consider maintaining an updated literature binder at the association's principal place of business. Bring the binder to all the meetings to make available for owner inspection. And consider preparing your own template in advance to publish on your association website to help owners with their requests. Anticipate that these requests will come in. The more prepared you are, the better. Consider speaking with legal counsel to make sure that any templates or form that you use complies with statutory requirements. It's important to note that if the association does make a list, a template or form, they cannot deny the owner's request if they fail to use that form. That, I believe, right. Okay, so this concludes the presentation. I just want to see if I can answer Any other questions? Let me see if I can go through a couple of these here. I did include some contact information here, just in case you want to email or phone us. We also have a very helpful YouTube site if you haven't been able to visit that yet. We have tons of videos on there. All our HOA forums are posted on our YouTube page, as well as previous educational videos from my previous cohorts here at the HOA Information Center. Let me see. All right. Again, I'll try and answer these. One question here is, must these records be produced? Or the question is, how often must these records be produced to owners? And is there any stipulation on fees charged to owners to produce these? Basically, it would be whenever a properly submitted request is submitted, if that makes sense, then the association should comply or address that request. The fees are usually determined by the HOA or CAM. Again, they should be reasonable. Question, where are the annual disclosures posted or disclosed? The HOA hopefully is posting it on the website if it has one. Otherwise, they're required to be sending that out to the owners within 90 days at the end of every fiscal year. What if the annual meeting minutes are not approved yet? So Kiowa does not expressly say the meeting minutes must be approved or not approved. But in any corporation or any business environment, the meeting minutes should be approved, just to indicate that that was the actual events that occurred at that meeting. Feel free to, like I said, put draft on each meeting minute page, watermark draft, just to let the owner know that, hey, we haven't had a chance to approve this yet until the next regularly scheduled meeting, but these are the draft minutes. Amanda, feel free to jump in. I'm just kind of going through some of these Q&As in here.
Yeah. Well, there's a question here from Tiffany. She is asking, do all record requests have to be responded to within 14 days or just requests for unpaid assessments? And are there different requirements for timely producing a requested record?
Yeah, let me find that slide again real quick. I believe it's only for the unpaid assessments. Let me see if I can find that one. So this one is just for requests for unpaid assessments on that unit owner's unit. So just for requests for unpaid assessments.
Thank you.
There's a 14 calendar day limitation on that request.
Thanks. Deborah wants to know, I have been unable to find out what the amount or the dollar amount of the current allowed assessment is under Kiowa. Is it $400? I found the written law, but how to find out the amount allowed each year?
So that's not exactly relating to records requests, but I think what you're referring to there is certain exempt communities that have capped expenses. I want to say it's section 117 of Kiowa. So yeah, that one's, you can send us an email. I'll try and dig up that information for you, but it's certain small planned communities that are exempt from, or that they have a cap on their, how much they may raise their dues on an annual basis.
Thank you.
I have one question here. Do transfer fees and status letter fees charged by the management company, but not by the association, need to be disclosed? Yes. That should be outlined in the management company contract, which you can request. You stated examples of what receipts to keep and mentioned payments to attorneys, management companies, et cetera. You said includes. Does that mean includes but not limited to? But yes. Basically, any like I said, any business transaction that results in a receipt or expenditure to the community must be maintained and produced. We have 50 years of architectural plans. Do we have to retain them? Check your governing documents to see that you're complying with your own governing documents. That's a lot of years of architectural plans. But according to the slide I had, let me just double check this. There was no architectural plan retention time frame. That I'm seeing here initially. So check your governing documents, and if you're hesitant, also consider speaking with an attorney on that. I would like to know if all these documents are available for free to owners. Kiowa allows HOAs and CAMs to impose a reasonable charge to copy and produce these records. Should these documents that you talked about be posted on the HOA website? Yes. Can disclosures simply be emailed? Yes. And trying my best to rapid fire answer some of these questions.
There's a question in here. Can unit owners also obtain, in addition of how many unit owners are delinquent, the dollar amount as far as and
Sorry.
what they can
Amanda,
provide?
can you repeat that one for me? Sorry.
Yeah. Can unit owners also obtain, in addition of how many owners are delinquent as far as the dollar amount? Can
I think
they
that should be an appropriate request, yeah, but don't expect PII information to be disclosed. Maybe you will get to this, but what are the rules on reimbursement to the person generating these records? I think if I'm understanding your question correctly, you're just asking about reimbursement, whether like like a director or manager would get reimbursed for generating these records. I don't know if I understand your question exactly, but the Kiowa doesn't specifically define that. The management company contract might. So even if owners consent to release of phone and email, we can't release them. I think I understand like where your question's coming from, because part of Kiowa is saying, well, any information that and that would be let me see if I can find that. The disclosure of information in violation of law. Well, as long as you're obtaining the consent just for the email addresses and telephone numbers, I think that should be okay. This one's probably more broadly speaking of other laws that might, the disclosure of which might be in violation, like medical records, for example, or maybe salary information. But as long as they have the written consent, it should be okay to produce those. Personnel records relative to HOA employees may not be disclosed. Is that correct? That is correct. Or they must not be disclosed. What about email blasts to the community where not all units are signed up? Excuse me. How long do those records need to be kept? For one, the HOA should double check to make sure that all the email addresses were obtained properly through owner consent. But that would fall under the category of all records to unit owners generally, which excuse me, that would be within the past 3 years to all unit owners generally. Let's see, we got about 1:55. We'll give it a couple more minutes here. One question here was how often are HOA boards and CAMs sued for failure to provide information? I don't have an answer to that question. You could consider contacting the courts, see if they have any information or records available there. Would referring an owner to the association's website be a proper response to the example request shown? Assuming all the documents requested are on the website, I would say yes to that. Unless they, specifically have requested hard copies of the records, for example. Are board member to board member emails considered a board record, which must be produced? We have some confusion in our HOA about this. If those communications resulted in some action being taken or a vote being taken, those have to be produced. I thought annual meeting notices have to be either mailed or delivered in person in addition to email. There is another requirement in Kiowa on meetings. I think it's section 318 that speaks to annual meeting notices. Does Dora believe that bank account numbers must be disclosed? Nowhere do I see that. In fact, bank account numbers should fall under must not be disclosed. Records that must be withheld from production include bank account information. Thank you so much, everybody, for posing your questions. There's so many of them. Okay, I think I'm going to call it though. So it's about 2 o'clock, and again, I really appreciate everybody for joining. If I'm more than likely I was not able to get to your question. I wasn't able to answer all of them, but again, here's our contact page. Our email address is Dora_DRE_HOA inquiries at state.co.us, as well as our phone number. Feel free to send us an email if I didn't get to your question. Again, thank you for joining our HOA forum. I hope you found this presentation to be helpful. And have a great weekend. Thanks again for joining, everybody. All right, bye-bye.